heard various witnesses today talking about the disparity of human rights standards in Northern Ireland, but you particularly want to talk about 3 issues, and the first of that is about abortion. Can you talk about your role in facilitating that legal change? I understand through your own client-based work.
So I acted for a number of individuals who've been at the direct coalface of the challenges to the abortion laws in Northern Ireland. Those include, for example, of individuals such as Sarah Ewart, who in her personal capacity initiated litigation to challenge the lawfulness of the compatibility with, in terms of human rights, compatibility of the abortion legislation, the Offences Against the Person Act, which included not only a direct challenge in Belfast, but also an intervention in the well-known Northern Ireland Human Rights Commission case. In addition to that, I've acted for a number of NGOs, such as Amnesty International and Women's Choices NI, who again have found themselves at the coalface in terms of dealing with victims who find themselves in the most appalling of circumstances. And I think it is important to give kind of context to those challenges, to what that entailed, and I think I outlined some of it in my witness statement. But we kind of must not forget that this all emanates because not the distant past, there was legislation in force in Northern Ireland which almost ruled out abortion in any circumstances, which resulted in a number of victims and NGOs having to bring about litigation to challenge those restrictions. And one of the most important factors that I think is worth mentioning, which unfortunately often goes amiss when we talk about abortion and the challenges in Northern Ireland, is what effectively prompted the sea change to the challenge. You know, it's not without note that this legislation was in existence in Northern Ireland for years and years and years, and it's with huge regret that it wasn't until recent times that challenges such as those, the Northern Ireland Human Rights Commission case and the case of Sarah Ewart, were brought. And the reason for that, I firmly believe, is, and the sea change for that, was the courageous step taken by those women at the forefront to waive their anonymity in the first instance to bring about the challenge, you know, such as Sarah Ewart, who vocally spoke out and advocated against the legislation. And it isn't without note, like I say, that up until that time, there was a great stigma attached to those women who were seeking, you know, basic access to basic healthcare. And again, it isn't without note that it was through litigation and the actions and advocacy of other women campaigners such as Grania Taggart of Amnesty International who ensured that those women who were at the forefront of the fight had a voice. And I think that when we talk about the abortion litigation in Northern Ireland, I think that it often goes unnoticed that those women had to share some of the most appalling circumstances, some of the most personal details of their lives with effectively the world when it became a public document. And I think that it's worth mentioning the significance of the sea change and the significance of having to waive the anonymity, having to take on the stigma that was associated in this jurisdiction. And I say that because I think the context which we'll come on to is that the CEDAW report proved a fundamental cornerstone for those women's rights, and indeed ultimately resulted in the end in paving a critical way to the repeal of the Offences Against the Person Act.
That's, I mean, I think your description of what the personal experiences of those women required in order to effect change chimes with some of the other evidence we've had this morning in terms of having an evidence-based and hearing lived experience, but doesn't, of course, underestimate the impact on those particular women having to live through that trauma just to effect the legal change to which they are entitled. So you said that the CEDAW report was a fundamental cornerstone. I mean, do you think that I mean, really, could it have been done without CEDAW?
No, and we can see that for a number of reasons. The first is that litigation was brought about, obviously, on the European Convention, and whilst that took us some way there into deeming that the legislation was incompatible with human rights, it didn't bring us all the way there. And what we've seen, and if you look at the chronology of events, is with regret the Supreme Court couldn't issue the declaration of incompatibility which was sought in the first instance. And then we had a period of time in which the advocacy strengths were brought to the forefront to try and call upon the Westminster government to change, to repeal the Offences Against the Person Act. As part of that advocacy, it wasn't just the advocacy wasn't just reliant upon the Supreme Court's comments, which were albeit obiter, but they heavily relied upon the findings by CEDAW. Now, the significance of that is apparent from when we seen the legislation, when we saw the legislation that brought about the repeal, the Executive Formations Act. We see directly they're included, expressly included under Section 9 is the references to the CEDAW report. And I think it's worth noting that when we look at that closely, that therefore, it's unequivocally clear, I would say, that the CEDAW report became the cornerstone of the repeal of the abortion legislation in this jurisdiction. And I think I can say without contradiction that had the Supreme Court issued the Declaration of Incompatibility, I dare say that we never would have got the rights that we now have in this jurisdiction only for the CEDAW report.
That's reinforced in terms of timing by the fact that it hadn't happened sooner. It only was post the CEDAW report.
That's absolutely right. And, like I say, that it was in the back of a Supreme Court decision, which unfortunately couldn't give the relief that was needed. In the meantime, then the advocacy continues, in which the CEDAW report is at the forefront. And it isn't until much later when the Sarah Ewart's case is before the Belfast High Court, in which a further judgment is issued. But by that stage, thanks to the advocacy efforts of those individuals I've mentioned, those women who waived anonymity, who relied exclusively and heavily upon the findings, not just of the Supreme Court, but of the CEDAW report, change was brought about. And you'll have heard earlier in the day from a number of witnesses who have paid testament to the complex political backdrop in this jurisdiction. And we can't forget that this was during a period of time in which there simply wasn't an executive in place. Power sharing had collapsed. And with it, the collapse of rights was anchored to that collapse. And we ultimately had a position whereby change was almost impossible. And it was only for the enacting of legislation directly by Westminster, which relied upon the CEDAW report, that affected that change.
That's very important. Thank you. And although we've had some change effected, we've still heard from other witnesses about the limitations of access to abortion in Northern Ireland, even now, post that legal change. And indeed, particularly in the context of the pandemic, I don't know if you heard that. I think you also referred in your witness statement to the pressure put on access to services and women having to travel. So if CEDAW were incorporated, what was your view in terms of how that would affect the access to those rights more directly?
Well, I'd probably answer that by starting with, I think it's a fair comment to say there's been a consistent theme amongst all of the witnesses who have given evidence today emanating from Northern Ireland. I think I don't want to reflect the record too starkly, but I think it's fair to say that unfortunately Northern Ireland has become the elephant's graveyard for women's rights. It is of great concern that we end up in a situation years and years behind England, Wales, the Republic of Ireland in terms of women's rights. And when asked the question, is there a downside or is there a benefit to incorporating CEDAW? I think that there are two very easy answers to that question. The first is, well, we have already seen the importance of CEDAW to women's rights in this jurisdiction. The proof is in the pudding. It's in the legislation. There can be no argument as to the importance for CEDAW. There can absolutely be no argument as to the importance for CEDAW of women in this jurisdiction. The second easy answer, I think, to the question about is there a downside or is there any greater benefit to incorporating CEDAW, I would say we are in a situation, and we just need to take a step back and kind of remember what we are talking about. We're talking about equality. We're talking about enhancing women's rights to bring about equality. So the question about without using the stereotype, the scales of justice and about equality, can you ever have a situation where somebody is too much or too great of equal to the other? I just don't think it bears any significance or any argument. The reality is you can never ever, in my view, have too great or too much protection in terms of bringing about equality. One can never be too equal to the other. So I would say that the answer to that is pretty clear. I think the greater protections that can be brought about, which CEDAW would bring, are self-evident. They're very obvious, and I think particular to this jurisdiction, whereby unfortunately we appear to be light years behind at times the rest of the world. It is increasingly important that legislation or protections, international protections such as CEDAW being incorporated, should be warmly welcomed. We should all be warmly welcoming such additional protections with open arms.